5 minutes. Thank you.
You may proceed.
May it please the court, I'm Tom Dandar, represent Gil Valente on this appeal of an order that basically overruled or overturned the predecessor judge's order finding entitlement to attorney fees under 57-105 for unsupported claim and for delays, and attorney fees under an accounting. To be
clear, Judge Williams' order purported to strike the prior order, which I'm not, I hadn't seen that before, a successor judge striking a prior predecessor's order.
I couldn't find it anywhere. Judge Baird denied that it would not touch the 57-105 in his prior order.
Well, and that's a lead into that, because before you get too far in your argument, I want to kind of understand what your view of what Judge Williams actually did here, because it was hard for me to understand. It was very clear to me that she was striking or purporting to strike Judge Minkoff's order. What I wasn't clear about was what happened to Judge Baird's order under her order under the motion for reconsideration. How do you read that?
Well, she struck that too, as far as the 57-105. Judge Baird would not touch Judge Minkoff's order. So when she said she was striking Judge Minkoff's order, that would wipe out whatever Judge Baird did. But I procedurally,
to the extent that Judge Minkoff had concluded that sanctions were appropriate under 57-105, kind of like by transitive property, I guess it would be that to the extent that Judge Baird's order upheld those, then that too was also being quote unquote stricken under her order for reconsideration. Is that kind of how you read that?
yes, I mean, after there were the second and third motions for reconsideration, they were taken like appeals to the same level of court.
So then that would leave as the basis for fees the failure to admit the request for admissions, right?
Correct in the discovery, yeah.
Okay.
Yeah. That was discovery violations for delays.
All right.
Under 1.380. But the and Your Honor, you were involved in the first appeal. This actually had a decision, the Razzie decision, and which found that my client's complaint was fine. No further comment on that. The judge granted summary judgment, Judge Minkoff, and allowed Razzie to go back to court on the counterclaim because he said he had documents, and he never had documents. And we've tried to get documents, didn't have any. Went to court on 100% inadmissible hearsay. Judgment was entered on the counterclaim. They filed a notice of appeal. They dismissed it voluntarily. And there was another order that they dismissed that it was a garnishment judgment against the bank. They were going to appeal that, and they dismissed that also. But after Judge Minkoff's, we had the hearing in August of 2019. Judge Minkoff entered his order on March 2020. And then we were supposed to have a hearing, but COVID canceled that because we weren't in a position to have it, didn't really know how to have it. So we moved it to September, and Judge Minkoff retired, announced his retirement. And he was going to retire on September 6th. And so that's when the counterclaimant defendant decided to go ahead and file a motion to qualify Judge Minkoff and the second motion for reconsideration. But through all the motions for reconsideration, up until even the brief here, the appellee never cited any 57-105 cases because they're all in the appellant's favor. Unsupported claims are sanctionable. And the counterclaim was unsupported. It had absolutely no evidence. Didn't have even the bill from Frontier that they alleged was opened by my client. He's admitted on the stand. He has no idea who opened it. So they had no evidence.
Was it a problem that, according to Judge Williams, the order had some infirmities or at least some shortcomings, which it didn't determine the time at which the claim was unsupported or the plaintiff should have known, or the counterplaintiff should have known that it was unsupported?
It says that right in the order, Your Honor. I did a detailed motion for the fees, and Judge Minkoff adopted it, but he had edited it the way he wanted it. over the course of from August to March. And then Rossi's counsel submitted their own order, which says basically the same thing without spelling out what was in my motion, or in the Lindsay's motion. It admitted that it was frivolous and all that, sanctions were warranted. So when they argued that it was not good enough, the one that was entered, it was more detailed than the one that they had submitted. But Judge Williams would not hold another hearing. She didn't unfind the findings of Judge Minkoff. She didn't make her own findings. And as a case that I've cited, O'Neill was dealt with a successor judge. Once there's the findings by the judge, the next judge can come in and make the assessment of fees. In that case, the fees it's very similar. I spelled out in my brief, very similar in the factual situations and how the claim was really unsupported because they never did do anything over the course of the years. This case has been pending since 2012. So they just never did it. And the cases, even the cases of Suarez, which I rely on, the most recent case on 5705 from this court, deals with exactly what I'm saying. If it's unfounded, unsupported, sanctions are warranted. I have quoted it in my brief, and they had absolutely no admissible evidence. And the thing is that statute changed in 1999, so if it's unsupported, it's sanctionable. You don't have to look further than unsupported. And the delays were found by Judge Minkoff through all the discovery orders that had been entered. Even after they were entered, they still objected to producing documents, which I found to be unbelievable. But the findings are clear in the entitlement order. I believe that the Judge Williams was incorrect in having even the authority to strike the entitlement order. If she's so inclined.
What about the portion of Judge Barrett's opinion where he overturns the award for the accounting? Are you conceding that? You're only on the 5705?
No, this appeal deals with the accounting because we didn't have an equitable accounting. It's spelled out, and I have it in my brief. It's spelled out as a matter of law. My client was entitled to an accounting.
But you didn't get that from the court. You did not get a ruling or a judgment that declares or decrees that an accounting shall be had. Where in the record would I find that the judge ever made an order that said, you have a claim for an accounting, court hereby declares you are entitled to an accounting, go forth and have your accounting? Where is it?
They set into the accounting because we had a right to an accounting. And we did the accounting through the court orders compelling document production.
That's not the same. Try my question, Mr. Banner. Where did the court ever enter a judgment or an order that said that granted you the relief? That's how we as an appellate court have to review this. We get a claim, we get a ruling from the court, and we look at it. Where did you ever get that ruling?
There's no such ruling.
Okay.
But there is account for an accounting.
I get what you're saying. You got the effect. It's kind of like, look, we proved our point. We got it across by virtue of the litigation.
Right.
My issue here is that may not quite be the same as actually getting relief from a court.
And correct me if I'm wrong, educate me. I mean, if you got the damages in the form that you got, you don't need an accounting really. In other words, that's the whole point. You got damages that, yes, perform tantamount to the function that accounting would achieve, but is there case law that?
No, they're intertwined. 57105 would start at the time they filed their counterclaim. And there's enough evidence, and I present in my brief, enough evidence, they did that as a knee-jerk reaction to having a claim filed against them for the $20,000 that Mr. Rossi put in his pocket. And he wouldn't do the accounting. So that's the only thing they admitted on the request for admissions is, no, we didn't give her an accounting. But she asked for an accounting before I got involved, but it wasn't done. But it's intertwined on that. The only difference would be to the time I filed the suit versus accounting.
I'm asking you to educate me on the law, and I'm sure your opposing counsel will. I thought the law was the opposite. The point is they're not mutually exclusive, but
What do you mean, as far as the,
If you got what you needed with your relief, the damages relief, then you didn't need the counting anymore. You didn't.
well,
need-
we didn't know what our damages were gonna be, because we didn't get the records from him. He was the one that held all the records, financial records. We had to go to the bank and get some records. He gave us some records, but not all the records. And then when we got the records, we found out there was a $14,000 check he wrote to himself for things that he wasn't supposed to do it, but my client wanted the case over, so we said, let's get the case over. But they continued with this counterclaim. They cite Moakley doctrine, and the Moakley doctrine specifically, the decision specifically says this is not 5715. This is inherent power of the court on its own, can sanction for bad faith conduct. But it's definitely not 57105. They cite no cases on 57105 post 1999 in anything they did on their before the court, lower court, and this court. But all the cases I cite on the accounting, they all granted the attorney fees as a cost, because you're entitled to the accounting under the statute, and you're entitled to get your cost back to get that accounting since Mr. Rossi did not provide it. But yes, under 5705, for the delays in discovery on this throughout the case and the frivolous counterclaim. The newer should have known is what the cases say. Newer should have known that the not supported by the facts. And then baseless claims, stonewall defenses, that's 57105. It's all sanctionable conduct. But yes, Judge Williams, the order we're appealing here doesn't say there's no, she doesn't make any findings. It just simply says that it's grants the motion for reconsideration and strikes the 57105. So and I include Judge Baird's order in here because in case, as you mentioned, hers doesn't mention the accounting part of it. That's why that's part of the appendix 6, because that I still find it to be error because the fact that she was supposed to get an accounting without having to hire an attorney to do so. And that's a cost for doing that. But that's only the difference between the time I filed the suit and the time they filed their counterclaim. There's only a difference in the attorney fees that be awardable in this case. Although I did file something you'll see in the record because I was asked to by counsel to differentiate between what timelines were for each thing. So it's spelled out on there, whether accounting or the counterclaim. But the delays cover everything else. So the cases I cite, it's unusual appeal in that the appellee didn't respond to any of the cases I cite in my brief, but the entitlement order of Judge Minkoff should be reinstated, and we proceed to have a hearing, an evidentiary hearing, which is one of the complaints of the appellee, evidentiary hearing on the reasonable amount of attorney fees to be awarded, and then who's responsible for it, whether it be the attorney or the client or both. But to cut it off with a denial of fees is not supported by the facts, not supported by the law, contrary to the law and contrary to the facts. Also, my argument I mentioned before, it should be an estoppel because he submitted the proposed order of Judge Minkoff that had less facts than the one the judge actually signed.
You're at your 5 minutes, Mr. Van Dar, if you want to reserve it.
I will reserve it, Judge. Thank you. Morning, Your Honors. Benjamin Hillard on behalf of defendant counter plaintiff Joseph Racy. May it please the court. This court should affirm and not disturb the trial court's orders challenged here.
Mr. Taylor, before you get too far into your argument, I want to ask a question about the brief that got filed here.
Certainly,
Was that signed by you, I believe?
I believe so.
I got the distinct impression that there was some personality conflict between counsel. This has been a long case, a long simmering case. I would ask you at the outset, with the benefit of some time, kind of cooler heads prevailing, is there anything in that brief that you might want to consider withdrawing? Any language in there?
I can't identify, like, maybe if I had it in front of me to go through it again.
Well, you state in conclusion that Judge Minkoff's ruling was, and I'm quoting, is based upon, quote, some corrupt purpose and not because it was based upon law of fact.
So,
Describe your opposing counsel's arguments as, quote, masturbatory, language like that.
so first, I had a contentious relationship with Judge Minkoff,
That comes through.
to put it mildly, and in fact, actively campaigned against him when he ran for re-election. I actually had a Facebook post that said, "Do not vote for Judge Minkoff. I've received my ballot in the mail this weekend." While I don't know many of
I
the,
think you're missing the point. The question is whether you want to soften, take back some of that language. Conflict or not, this is still a court of law.
certainly, I'm willing to do that, absolutely.
Please continue.
Go ahead.
Thank you, Your Honor. And basically, I concluded that in my Facebook post, and it's available in my brief, that frequently I asked Judge Minkoff when I had case law that supported my side and the other side didn't really have anything contradictory, he would rule in the other side and I would ask him for a legal basis for his decision. And he would scream at me that you have my ruling, and he would never give one. And I contrasted that in my Facebook post, that his conduct stands in sharp contrast to good judges like Jack Day and Jack St. Arnold. And while I frequently disagree with their decisions, they can state a legal basis and therefore.
So hard feelings about,
Yes.
whatever feelings about Judge
Correct.
Minkoff aside, can you tackle the issue, quo warranto, by what authority does Judge Williams, as a successor judge, keeping in mind principles of comity for predecessor Judge Williams, what authority does she have to strike a predecessor judge's ruling that's based upon his assessment of the merits of a claim and facts that were presented in a trial in which he presided?
So to narrow that particular issue, the order itself doesn't identify the who, the what, the where. And
You're talking
that's
about Judge Minkoff's.
correct. Judge Minkoff's order doesn't identify the who, the what, the where. It is not sufficiently specific under the law for Judge Williams to step in and say, did this cause of action become, and I forget what the word, frivolous? Did it become frivolous at a certain point in time, or was it frivolous at the beginning? Like there was no.
Are you saying you're making a practical point, which is it's hard to assess the amount of fees, even if you were to presume the entitlement was correctly arrived at, because you don't know at what point entitlement arose?
And correct.
Couldn't
That's
you infer from Judge Barrett's order and Judge Minkoff's order that the prior judges deduced or concluded that at all times relevant?
no, you cannot from Judge Minkoff's order. In fact, the Second District Court of Appeal stated.
Well, the Second District Court of Appeal just said he said in a deposition that he had goods.
And that's not true. That's not true.
Might have factored into the trial court's thinking about why.
It was largely a
the
circumstantial
for the sake of
case.
discussion inferring from the orders entered that at all times pertinent, the counter plaintiff knew they didn't have what the facts necessary to support the cause of action. The appeal itself plays into that.
We had multiple admissions from Plaintiff Valente that she in fact had a separate phone line, that she bought a property down the street.
Okay, well, we can presume all that true, but you need to prove damages for a claim of, I mean, what was the claim again? Negligence?
The claim was for,
Or was it, what was the claim?
the claim was for his credit.
What was the claim? What was the cause of action?
I think it was negligence, you're correct.
So negligence, so presuming that her getting a second phone line in the condominium was wildly unreasonable for the two prior judges to have concluded that the counter plaintiff at all times pertinent knew that they did not have the relevant facts to prove damages, that there was some sort of damage to the credit report that could be quantifiable, that could be even supported at all.
So those facts he had, it was just connecting the dots
Did
to
you
show.
really, I mean, because I read through the trial transcript and your theory of your client's theory of damages was that they would have gotten a more favorable refinancing rate, correct?
Correct.
Right, which there was no evidence presented from, admissible evidence presented from the bank or lender or what the terms of that actually would have been. It was just your client trying to put hearsay before the court that I was repeatedly told, no, you can't do that. So in terms of admissible evidence, there wasn't anything there for damages.
We didn't get to the
It was
part
right
of
out of the
damages.
gate. It was that issue came up right out of the gate in the trial. It was one of the first issues that got talked about was what the spread was, what the beta was between what you would have gotten for the if she had been able to successfully refi versus what she ended up having to, because I guess the rate went up like a couple percent.
That's just a financial calculation.
But you still have to, yeah, I mean, that's
Right.
all well and good, but you
Right,
still have
because
to put evidence on it. You
The
didn't.
causation largely boils down to the he said, she said. And she made various admissions in her deposition and nearly at trial.
Well, I mean, he said, she said, and because there was an unpaid phone bill, there was a credit, a substantial enough, or there was, that actually caused the credit rating to be reduced. And that actually that was the factor upon which the bank based its decision to lend only at a rate that exceeded what
Correct,
counseling could have done.
correct.
So what was the evidence?
What was the evidence of that?
What
The
was
credit
evidence of
report
that?
itself.
I don't recall if that even got admitted. I think
It wasn't admitted.
right, because it was hearsay. And then also your client tried to relay about, well, somebody told me this over the phone. That got objected to, it wasn't admitted. There was nothing, yes, I think your client wanted to be able to get this, wanted to be able to relay about this, but is it that far beyond the pale for purposes of 57-105 analysis to state or to hold or rule that, look, you have to, it's not a question of what your client tells you, it's a question of what you can reasonably anticipate putting in front of the court to make this determination. And if you don't have anything there that can be put in front of the court, I mean, your client's only basis for this loss of the percentage on the loan was what someone else told them, right? So even taking
He was denied a loan.
correct, but his only basis for getting that in is to say I would have gotten this and I was told by somebody else. That I was told as the attorney, you got to know, hey, listen, we're gonna have to get this from somebody else, right?
He can say that he was denied the loan. He can certainly say, I applied for a loan, I was denied the loan because of my credit rating. He can certainly say
How can
that.
he say because of my credit? how can he say that unless he's parroting what somebody else told him? This is the same about that. This is just kind of a replay of what happened at the trial, right?
Right. I would like to answer your initial question. Right out of the gate, Judge Baird set aside the portion of the order that had to do with the false claims that Valente prevailed on the accounting cause of action. And then subsequent to that, Judge Williams set aside the 57105 basis because the order lacked specificity. To answer your question regarding the cause of action for the equitable accounting, it was brought as an equitable accounting. That's what the cause of action was for. And plaintiff's counsel repeatedly identified it as being that $14,000 amount that was in dispute. And an equitable accounting is a cause of action where the court sits and takes evidence to determine how the complicated accounts are separated. So that 14,000 was in fact intended to be an equitable accounting. So, and that's part of why I think Judge Minkoff, aside from our personal disputes, he went ahead, even though he knew, and I point out in my brief, areas where I told him the true facts, he still adopted the false claims that Valente prevailed on that equitable accounting cause of action. And Judge Baird looked at that and said, no, there was never a final judgment entered for the accounting, and no actual accounting was ever ordered, performed, or submitted. But Judge Minkoff adopted that as truth, even though the record shows that he was informed repeatedly that it simply didn't happen. And in fact, if you were to look at the plaintiff's counsel's motion for summary judgment, where he turned the partial summary judgment into the final judgment, in writing, they abandoned that accounting, what they identify as the $14,000 cause of action. So just to circle back to the legal standard for denial of attorney's fees is abuse of discretion. So while Attorney Dandar attempts to point to or identify an exception to that, that exception is only applicable where a judge interprets 57105. The issue here is the judge did not interpret 57105, simply looked at the order, and the order was insufficiently specific. Like I said, it failed to identify the who, the what, the where. Instead, the order quotes the statutory language, and that's it. And if the court is going to sanction parties or their attorneys, the law requires a high degree of precision.
Where are you getting that from? Is that from case law construing 7105 post 1999?
It is, and it's referenced.
Post 1999.
I'm not sure if it's post 1999, but the same. There's no reason why that high degree of precision wouldn't apply when you're talking about sanctions of a party.
That's a little bit of a jump, don't you think? I mean, the legislature substantively changed the threshold requirement of what will implicate fees under 5705. I mean, they lowered the bar, to use a metaphor. So why would we look to pre-1999 case law to inform us what kind of findings are necessary for a post-99 amendment when the post-99 amendment was a substantive change?
Even if you say it was a substantive change, it still would require tying out specific conduct in order to enter a sanction, in order to determine the amount.
Well, I think what Mr. Dandar would argue, and I'm curious about your thoughts, isn't that really just a question of, at that point, we're talking really more about amount rather than entitlement, right? So maybe there's an order of entitlement as to fees, and then you have an argument about, well, what fees were really incurred as a result of sanctionable conduct, and you have that argument plays out however it plays out.
And Your Honor, the issue would be that for example, Judge Minkoff didn't hold an evidentiary hearing. He didn't inquire of Mr. Racy or myself. He never inquired as to which attorneys at my firm handled this case. from
Right, you didn't
start
get to that
finish.
point because you all were successful in your motions for reconsideration.
All of those things needed to be put for Judge Minkoff's order to stand, needed to be put into Judge Minkoff's order. But I would say he didn't have enough to actually tie out anything. He just broad brushed it because, in my opinion, he didn't like me and he saw an opportunity to ding me. That's the conclusion I have to come to. If the order identified specific conduct or specific time, or the judge actually took the time to do an evidentiary hearing and inquire as to which attorneys at my firm handled this case. I handled it in the very beginning, and then I handled it at trial. Would I have done things vastly differently than things got done leading up to that? But I know, like, I can't basically, once we get to the eve of trial and I look at my folks and they're like, well, you're doing this trial, and yes, I would have, if it was me the entire time, I would have done things differently in the middle, for sure. But there was never any inquiry from Judge Minkoff regarding any of that stuff. I believe he just saw this as an opportunity, and based on just the simple fact that he was willing to adopt the false statements that Valente prevailed on her accounting cause of action. I mean, that says a lot.
So in your brief, you did emphasize that a lot to the exclusion of really addressing the case law of the appellant. And the issue that Judge Lucas just talked about, and I did, which is the change in the rule and what case law supports the provision that's post-claim. Just indulge us in presuming that pre-1999 case law is inapposite. What case law supports your position that Judge Minkoff's order, similar by one order, was sufficient?
So the issue is, there has to be some tied out specific basis for a finding if the courts are going to go about sanctioning parties and their counsel.
Okay, start with the rule. The rule says, I mean, one could get philosophical and say it's not even really a sanctions rule anymore. It's just a fee shifting rule. If we find that there was never any this factual or legal support for your claim and you knew it.
If there wasn't precision, then there would be no way for the court to balance, as the Supreme Court says.
Okay, so why can't we infer from it that there was enough precision to say that the court concluded that the claim never had merit, and that began at, shortly after it was filed? Because
Judge Minkoff didn't engage in the appropriate inquiry.
Well, what case?
All of the case law says.
What case? So the case law says, we scrutinize the proceedings and the factual findings required in any case law, and the rules require that. The statute doesn't require that. What cases say Judge Minkoff got it wrong because there wasn't enough specificity?
I can't identify any specific case off the top of my head that says that. The case law, all of the case law, and yes, much of it is before the statutory change, but that requires specificity. And so if it's gonna prohibit, if the statute was going to make a change of all of the law that requires specificity, I believe it would have identified it. Otherwise, it would discourage zealous representation of your client.
Okay, let me ask you this. So I can understand the logic. There's taking your point as just a logical point as opposed to one that's specifically supported by ironclad case law post 999, that, you need to show why, why it was unsupported by the facts and why, or the law and when that was known. But can we rely on the really extensive dialogue at the hearing, not to drudge up bad blood, but there was a lot of talk about, the judge was pretty specific in what he explained to support his position that this was bad from the beginning, he knew it.
And that's
You're out of time, but I'll let you go ahead and answer that question before you step down.
certainly, Your Honor. That was how most hearings that I had in front of.
I just want to know, can we rely on that? Can we take the judge's reasoning that he put on the record in the transcript? Is that enough specificity for us?
It's not. It's not even close. There has to be some sort of an evidentiary inquiry with specifically identifiable facts of bad faith conduct, that type of thing. Thank you.
Thank you, counsel.
And the answer brief, appellee cites the Ferdy case from the 4th DCA, although in Cronman versus Stiles in 2015, the court said they received from Ferdy because that's pre-1999 statute law. Said while Perlman and his project were good law under a pre-1990 version of the statute, we're compelled to recede from our holding the case because the statute was amended. Court only has to find that the losing party or the losing party's attorney knew or should have known the claim or defense when initially presented to the court or any time before trial was not supported by the material facts or would not be supported by the application of then existing law to those facts. So and that's very clear in Judge Minkoff's order, which should be reinstated. Again, the argument I got to bring back on accounting because it's discussed about complicated accounts.
Okay, since you're on that, could you just address the motion for entry of summary final judgment and the contention by opposing counsel that you could prove the accounting claim and said as the plaintiff decided to forgo further litigation involving $14,466?
The accounting, as far as we could get done, was the $14,000. The accounting cause of action does not ask for damages. The damages are up in the first count with the breach of the statutory duties. We incorporate the statutory duties into that accounting count.
You were relinquishing damages sought in the first count when you said as the plaintiff has decided to forgo further litigation involving $14,466.
Yes, that's what our accounting uncovered, $14,000, which Mr. Rassi paid to himself for things he wasn't supposed to pay for himself, for pictures that he got back at the sell of the condo, and he said, I put those in there, so I won't
You weren't
remember
saying
that.
we no longer need an accounting.
Pardon?
You weren't saying we no longer need an accounting.
I never said we no longer in the accounting, never abandoned the accounting claim. We my client forego the damages.
I still want the accounting, but.
We already did the accounting.
Right, well, that's another.
Well, I mean, we already did the accounting. If you look at my brief, I have all the responses to requests for production. Every time, even after the court ordered to do so, we object to producing any documents that's not part of any cause of action. So if we did not bring the accounting cause of action, he would have been objecting to that and saying, well, there's no reason for us to give you these documents, no reason for us to give you our financial records or the bills that we spend or whatever we have. So you have to do an accounting when you got a partnership breaking up like this to find out what else, especially since he wanted to get a release, personal release, only from my client, not from himself. Personal release saying that all the accounting is good. Well, it just didn't have good in the accounting. And he put the check in his own pocket.
If you have this kind of de facto accounting that occurred just by operation of the progression of litigation on the damages count, you were entitled to the fees and costs, right? What case?
The fees are as cost, fees taxable as cost for
so
accounting.
what cases support that? This sort of like ad hoc de facto
There was
accounting that happened by just the virtue of the litigation itself, entitles you to fees and costs attendant to
The cases,
cause of action.
the cases cited in my brief and reply brief, there was, well, they didn't even bring a cause of action for accounting. They awarded attorney fees as a cost because accounting actually occurred. So, and that was, there's nothing that's saying it was done through the court as far as a court order on accounting because there was no cause of action for an accounting. But the, some of those cases deal with, someone was handling a real estate for an estate. And the beneficiary wanted accounting for all the fees, or for all the costs associated with that. And they were awarded attorney fees for getting that. I think the one, the case is cited by the court, which was cited in my motion for fees, I want to say Lipstick, they didn't even ask for an accounting.
Okay, the real estate case and the case, I don't want to dominate the rest of your argument.
Coming to the end of your time, Mr. Van Dyke, if you could wrap it up. in 20
Um,
seconds.
I covered it all, Judge. Thank you very much.
You're welcome.
Thank you.
Next